All right, thanks, Rick. I am here to talk a little bit about cyber and tech policies, particularly bring your own device policies, which, as we know, is a growing trend here. So I just want to ask a question. How many people in here have their companies allow employees to work with personal devices, like phones, laptops, things like that? Okay, a large number of hands. A few years ago, probably not as many hands, and that's part of just generally the growing trend. And there's legitimate business interests supporting that kind of tech. You know, you get to lower a lot of company costs by having people bring their own devices. There's productivity. You know, you come early to lunch like this. You finish lunch, you could have 30 minutes to do some work. It's a great tool to serve a lot of those business interests. But at the same point, like chief executives, a lot of directors get asked questions about, you know, what's stopping your company from implementing policies like that? And the number one concern is security. You know, bring your own device policy, or a BYOD policy, is really one of the best ways to address this type of security concern. At the same time, you've got a policy in place that sets expectations with your employees and really communicates, you know, what your company likes to see out of this as, you know, serving the business interests as opposed to just, hey, we got this so that we can keep up with everybody else. You know, the bring your own device policy really should be thought of a little bit like car insurance. I mean, you wouldn't go around driving a car without insurance, not because it's something that you really think about all the time, but when something goes wrong, you look back at the terms and see what kind of protections you have in place. And that's kind of one of the interests that gets served in a BYOD policy is when something goes bad, you know, what kind of terms do you have in place? And particularly scenarios like an employee leaving the workforce, somebody losing their personal laptop, you know, exit interviews, things of that nature. And so talking about a BYOD policy, if you don't have one in place, or if you have one and you're thinking, look, nobody's looked at this for a few years, you know, what can we do to make it a better fit for our company, considering you can't really go a few days without hearing a news feed about some type of breach or hack. And so, you know, considering these kinds of policies, I've just got some bullet points here of what you should be thinking about, but really, these policies are not one size fits all. If you just go on the internet and you search for a form, you'll see a vast variety of what these policies look like, what they address, and it really is because different policies are for different businesses that have different interests in why they allow employees to sort of access work information, not on the job site. You know, there's a lot of benefits, like I said, lowering costs, improving productivity, and as Flip had talked about, there's a lot of recruitment involved there with the incoming workforce. But seeing a lot of different policies and having reviewed those kinds of things, I tell you that there are major differences in companies that, for example, have very valuable intellectual property that needs to be accessed frequently versus a company that wants to improve communication and have employees have access to email. You know, the different interests will require different types of policies. You know, before implementing policy, looking at those interests and what you want something to look like for your company, there's a lot of new tech that's out there. A lot of new software applications. A lot of startups are coming out with various applications that will help address issues like the security concerns. One of the terms that you'll start to hear more of if you look around at this kind of tech is sandboxing. And that's kind of a concept where you have something in your policy that implements, you know, how people use their devices. One example of that is somebody using a mobile phone remotely. It looks like they have access to their email system, but the application for bring your own device actually is kind of like they're working off a copy off of what's in your servers, so that if something goes bad, they're only really messing with that copy, and you can separate it out from, you know, the core information or personal health information, stuff like that you have for employees. the flip side of the sandboxing ideas on mobile phones. If you have employees use their mobile phones, they can have certain applications that are only work-related, and therefore, if they lose their phone or something happens or some kind of breach, the company, IT department, just has to click a button and it wipes just those applications and doesn't mess with somebody's personal photos, text messages, things of that nature. That's something that's fairly attractive because the incoming workforce has a very high level of sense of identity and personal privacy, and these are some of the tech methods that you can use to address that a couple of years ago really weren't that available. So talking about benefits cut against the realities of, hey, if you have people who can access work from their phone and communicate that way, you're going to have a whole lot more data going around. One of the considerations that's often overlooked is while you're lowering device overhead, you're raising IT overhead. And of course, you've got a lot more communications going back and forth, as a lot of HR people know. That includes kind of off-the-cuff emails between employees, things that you guys love to just hear about, right? So talking a little bit about implementing a policy. One of the things that we're seeing, and Flip sort of mentioned this, the incoming workforce is very tech savvy. There is somewhat of an expectation that they have ability to have that work-life balance at all times, whether or not that takes the form of access to work information on their phone, being able to communicate at all hours, against whether or not the company wants to just maintain control and issue its own devices. Sometimes if you undertake kind of a cost-benefit analysis, it actually comes out in the company's favor to just have a certain number of devices. You've got them all registered. You can control the type of software that's on those, and that addresses the main concern of security while allowing kind of those type of perks. The tech hardware isn't quite there yet, where there's phones that are kind of dual-core phones, which essentially is two phones in one, but you'll be seeing that soon. If you have ability, or if you allow employees who are not exempt employees to access work on their phones, and they're at home at midnight and they get a ping and they go on the phone, they answer an email in a few minutes and they're done, it's the same as if they're punching in and out. And so you got to be wary that there are potential wage claims for that type of a situation. So a bring your own device policy, think about who does this apply to, and are we limiting it to exempt employees, and if we're not, how are we addressing the issue of somebody's got their phone at all times. You got to also understand that if you expand the scope of employees and you expand the scope beyond what is really necessary, you can set a standard for reasonable accommodations. People with disabilities or people on leave who want access, and if your policy, if you have a BYOD policy that's not targeted, you can really be setting a standard for reasonable accommodation claims. And basically, one of the thoughts that I preach is take a look at what kind of tech you need and have it be kind of an intra-department discussion about, hey, look, if you allow employees to use their phones, every once in a while you should go back and have a conversation with operations, IT, and HR to think about, is this right for us? Is it too broad? Or if you're thinking about implementing a policy, think about, let's do kind of a pilot program. How does that look? Who do we want to be able to trust with this? What kind of devices work with what we're looking at? And what type of applications are out there? And what kind of cost are we looking at as far as overhead and IT? The number of hands that came up is also telling of where criminal activity is going. As more employers implement these things, there is a greater trend of hacking and targets. Just 2 weeks ago, a cybersecurity firm, Avast, announced that hackers snuck malware into a program called CClear, which is a product that is widely used that is intended to clear space, improve speed on Android and PC devices. So this is a approved, legitimate piece of software that basically could be used by employees to speed up their phones, speed up process, but at the same time not realizing that if they weren't updating and patching that software, their systems were sending information out to hackers. Not necessarily a breach itself, but sending information out to hackers so that they would know how to hack them with something big next time. Again, yesterday, Deloitte just announced that admin email accounts were hacked and access to client data. Deloitte is accounting firm for a lot of Fortune 500 companies, and it's because some of the admin emails failed to use two-factor authentication, basically meaning that the hack happened a while ago and they didn't know it. And if you're allowing employees to use devices, and this applies even company-wide, if you have policies in place, at what level do you make it more secure? At what level are people having direct access to valuable IP and company information? So I want to talk a little bit about how some of these issues kind of come to a head and why BYOD policy might make sense for your company, even if it's not something that is sort of critical at the moment. Some of these real-life examples may help you think about what you need to look at. So this Krotner versus Starbucks case went all the way up to the Ninth Circuit, and it was about a company laptop that was stolen. And the laptop had names, addresses, social security information for over 90,000 Starbucks employees. And the issue in the case was whether or not employees, Starbucks employees who had, potential breach of their data had standing and a real injury to bring a lawsuit. And the court found that basically the answer was, when there was a real and credible threat of actual injury because these employees actually signed up for credit monitoring, that there was an injury in fact, and therefore these people could bring a claim even though they didn't have any actual showing that their information got hacked, they were denied loans or anything like that. So translating to our discussion today, if you've got a BYOD policy in place that requires certain information or requires applications to have encryption, or there's sandboxing where an IT company, the moment something's stolen, can hit a button, wipe everything, and then they can go back and look at the log files and see if any information was accessed. You can kind of head off a potential claim like this. Washington has a breach notification law that requires companies to do certain things when there is a breach, which is personal information gets out there. Now there are some safe harbors in the statute, which again, if you've got a policy in place that addresses these issues, you don't have to go through all the hoops that the Attorney General in the state requires if there is a breach. So by having something up front, you kind of insure yourself against the real potential issue down the road, because you can't control at all times, what employees do with their phones. Do they, leave it at a Starbucks and it's stolen? Companies, small to mid-market companies usually have those types of hacks or those types of breaches, not directed, people from Eastern Europe trying to hack accounts and then lock down and ask for ransomware. But under the law, the requirements are basically the same of what your company has to do in response to a breach like that. Recently, we've seen an uptick in cases being filed in Washington, which are class action cases based on breach of information. For example, Washington State University, this case is going to deal with the issue of injury in fact, and that's where Wazoo maintained a backup hard drive in a safe on an off-site storage facility. And the hard drive had names, personal information, social security numbers, health data of alumni, potentially hundreds of thousands of WazU alumni go over. So a handful of people, when they found this out, went out and paid, just, I don't know, $25 to get credit monitoring for a year. That, under the Starbucks case, could be an injury in fact. All of a sudden, you've got a lead plaintiff in a class action lawsuit. We're going to start seeing an uptick in these types of cases because the way that the Washington law is structured, attorneys can have the ability to recover their fees. That makes these kinds of cases very low risk for plaintiff's attorneys because all these people have to do is spend a few dollars to get this credit monitoring, to get the injury, and be able to go out and be marketable to plaintiff's attorneys who want to bring cases, get fees, and go after companies for this because it's very easy to identify breaches of the standard of care of companies who, for example, don't have BYOD policies in place, don't have incident response policies in place, have never consulted anybody in information security or information tech about what to do in these kinds of situations. So, this is something that we're seeing more of, and basically the law will be reactionary to it. So you'll see an uptick of these types of cases for the next few years. The other aspect is discovery in litigation. So if there is a lawsuit that involves your company, what kind of obligations do you have if you've got a lot of employees out there who have access to company information? What happens when somebody leaves the company and they take with them, the access that they had and you hadn't shut it off for a few days? How do you track that? How do you figure these things out? This Living Color case was about if you're allowing employees to use, for example, phones, are you controlling the phone and all aspects of it, or do you have something really in place that says this is how you use the phone for work purposes? The issue in Living Color was that the company got sanctioned by the court because it turned out that there were some text messages that were relevant to the litigation that were produced, and the company basically didn't have any knowledge that employees were using text messages for work-related issues. But for our case right here, or what we're talking about today, if you had a policy in place, you could use that as kind of a defense. Text messages, we don't even control those. But not having a policy in place could lead to some liability in a situation like this. The Cotton versus Costco case is kind of the opposite example, where a court found nothing wrong with Costco not going through all of its employees' phones because there was no evidence that text messages were accepted or were any kind of business-related communication. You can implement a policy in place that sort of tries to segregate those things that say, look, this is work email, this is the only thing you can do on phones, and if you relegate the type of information that the company can review on an employee's personal device, you may find yourself in a situation like the Costco case where you avoid a whole bunch of legal fees, a whole plethora of sanctions by not having to go through employees' text messages, personal information, because you don't control that. The small case is a situation where if you allow personal devices and information to be used by employees for work purposes, but you don't do a good job of monitoring it. For example, in the case here where a lawsuit was brought and the company searched did its normal course, searched for information about these employees on their servers and available information, and then 90 days later realized that there might be other information on employees' personal devices. Well, in those 90 days, they didn't put a litigation hold or inform employees about this, and what happened is A lot of phones have kind of default settings, like text messages will just delete themselves every 30 days. That was something that got them heavily sanctioned by the court because basically it was information that you controlled that you didn't do a good enough job of preserving it. And so after the expiration of 90 days, a lot of data and information was lost. And so the company immediately got, well, the company didn't immediately, but the company got sanctioned by the court. So same kind of a situation where for a bring your own device policy, one of the things you really need to think about is how are these employees actually starting that process? How is it that they have their phone and start to use it? You know, one of the best practices suggestions is IT needs to be a gatekeeper. You know, before those phones can get used or before these laptops can be used, they need to be brought to somebody who, you know, registers the device, you know, make sure the software applications are up to date so that you've got a record in case of a situation like in the Small versus United Medical Center case where you have to go out and identify and lock down the information that's there. So some more best practice tips, and I want to go through a few of these because, like I said, these policies aren't one size fits all, and so as a result, part of this exercise is something that we could provide you guys if you're thinking about revising or implementing a policy. You want to go through these types of questions so that if you do want to go the extra step and actually have us review a policy or something like that, you've already answered a lot of these questions, and it makes it real quick and easy to take kind of what we've got and pull out the things that work for your company. So the right to monitor and access employee-owned devices. This is really important, but you have to balance it against the privacy interests of employees. And you know, when I say that, there's options like what kind of tech's available, the sandboxing concept of, hey, we're going to be good because at certain events we will tell employees, look at company investigations, you know, when you leave, when there's litigation, we've got a right to go through what's on your phone, but on work-related information. If you just have a blanket, we get access to your phone at any time we see fit, you're going to run into some real privacy issues and potentially expose the company to liability where it's not necessary. You know, same concept with reserving the right to wipe and delete employer proprietary information. IT or somebody at the company should have the ability to remotely sort of blow up what's going on somebody's phone or somebody's data because of the potential of, you know, lost laptops, you know, stolen cell phones. Somebody's house gets broken into, you know, no fault of their own, something gets taken. IT should be able to hit a button, wipe that out. And you want to put these in a policy so that it's very clear for employees that, hey, look, if you're not doing what we're telling you to do as part of the policies and you're intermixing, you know, personal data with, you know, work applications, everything can be lost. It's better to have that up front in a policy versus fighting about it later on. You know, identifying the scope of expectations. I think this is pretty important because there's a whole lot of issues about, you know, boundaries. You know, what fits in workbox versus otherwise. And you know, again, you don't want non-exempt employees being able to check emails at all hours of the day. You can set yourself up for a wage claim lawsuit. If you're having trouble thinking about what kind of expectations these are, start a pilot program with just a few employees who are high level, or you know, a few employees at different parts of your department. You know, think about what the essential functions of certain jobs are and tailor the policy to those essential functions. That way you can insulate yourself against potential accommodation claims that you aren't accommodating somebody's disability. In Washington, there's no requirement for reimbursement. So there is no law, state law, that says, hey, if you allow employees to use personal devices, you have to pay a certain amount of their bill. It is a perk at this point, but for example, in California, it is state law that you do need to provide reimbursement. So it's likely that we may be seeing this down the road. So if you're thinking about underwriting the cost, think about, is this a perk? Do we want to reimburse? Should we just front load in some of these costs? Preservation requirements, do you have something in your policy that says, hey, look, upon these incidents, we can lock you out? If somebody really relies on personal laptops working from home, how big of a problem are you going to have if you need to lock out access because there's a breach somewhere else? And again, there's tech available. You can access and create different server space specifically for log files related to people's personal devices, where you don't have to actually grab somebody's device to see what they're doing. But are you disclosing, you're identifying that this is something that you can and will do for work-related information? Do you want to implement time tracking software? Those kinds of things. You want to limit the software that people can download on their phones. It's probably not really going to be controlled, but if you've got these kinds of policies in place in case litigation comes up, it's something you can address down the road. So, a lot of these things are just the general best practices that we're mentioning because they're all considerations to really think about as far as don't just roll out a policy and not think about the implications of it, because there's a lot more security concerns that can be addressed, but at the same time a lot more tech and software application solutions that are out there to help you out. The policies, like I said, if you don't have one, it's a good idea to start thinking about how you should put one in place if you're allowing employees to access that data. And it's really not that burdensome to go through and figure out and answer these questions and then flip it to attorneys like us, and it doesn't take long to do that kind of a review if you've already gone through and had these considerations. If you want to come start from scratch, it's a little bit more difficult, but hopefully this is some information that can help you think about some of these concerns if you've got them. Feel free to reach out, contact us with any questions.